we have three parts to this project, and they are each interconnected. And even though we're bringing to conclusion now the second part is the final piece, the pieces have built on each other in some interesting ways. And it's just been really rewarding to see the way in which at each stage of the process we've had such meaningful contributions and been able to produce something that really reflects a collective judgment.
And so the goal of the project is to provide those set of principles and guidelines to give that robustness, that structure, that if you follow these principles, it will be a fair adjudication, and that the public can have confidence that the resolution of the dispute is democratic, is legitimate, in accord with our country's values, and not simply a power grab by one side or the other.
One of the reasons to encourage states to identify these procedures with great specificity in advance is so there's as little room left for courts to feel like they've got to be making the law as they go, because it's in those circumstances that the best intentioned court might still be perceived by the public as having now, in the thick of the dispute itself, made the law or interpreted the law in a way that favors one candidate over another, arguably in a way that the public might perceive as partisan rather than neutral.
The states all approach closely contested elections a little differently. And the one thing that you find that's true in every one of these cases is there's a great amount of political pressure brought to bear on the election administrators. The election administration is obviously our elections are run by the states, and in many cases by county officials who go to work each day and try and construct and run fair elections. And for the most part, they toil in anonymity without a lot of attention until all the attention of the world is focused on them, and they're working long hours under a lot of pressure, being accused of misconduct or worse in the way that they're counting the ballots. And they need this sort of guidance. A lot of times the law is not entirely clear or hasn't been developed in a particular state. And so you have, I think having a neutral third party, especially one like the American Law Institute that has such a powerful voice, can help in advance clarify the rules so that as the contest unfolds and chaos descends upon the election administrators, they have something that they can grasp onto other than whatever might happen to exist under the existing state law.
One primary goal is to have state legislatures adopt legislation based on the principles and ideas throughout this project, parts 1, 2, and 3. Because the general principle of election law is the more that can be specified by statute in advance, the better off we are. Because, it sounds like a cliche to say an election is a game, but it is a contest, it is competition, and so the game should be played according to the rules, and you need to know the rules. If you don't know what the rules of Monopoly are, how do you play the game? You need to know the rules of elections. So it's really incumbent upon the legislature to be specific and clear about those rules. And our project, we hope, provides that guidance.